The content of this podcast is provided for general informational and entertainment purposes only and is not intended as legal advice. The content of this podcast does not establish an attorney-client relationship between the hosts or the guests and the general audience. If you need specific legal advice for your legal matter, please contact an attorney in your area. This is the Nursing Home Abuse Podcast. This show examines the latest legal topics and news facing families whose loved ones have been injured in a nursing home. It is hosted by lawyers Rob Schenk and Will Smith of Schenk Smith LLC, a personal injury law firm based in Atlanta, Georgia. Welcome to the show. Hello out there, and thank you for joining us for episode 37 of the Nursing Home Abuse Podcast. My name is Rob Schenk.
And I'm Will Smith.
And we are Georgia trial lawyers concentrating in the areas of nursing home abuse and neglect, and we are your co-hosts for this podcast. For those of you that are regular listeners and regular watchers of the podcast, you will know that we had a fantastic guest. The actual inaugural guest on this program, his name was Scott Fields, and he talked all about the probate process when your loved one passes away at a nursing home or really passes away anywhere. And we talked at length about heirs, things like that, and that actually got me thinking about a movie that Will is always talking about. In fact, he has this movie's poster in his living room. When you walk into his house, this poster, giant poster, I don't know how he got it. He must have worked at a movie theater because that's the only way he could have gotten it. But it's the movie King Ralph
with John Goodman.
With John Goodman from like 1988. This is where the entire royal family is electrocuted by a photographer, leaving John Goodman as the next rightful heir to the throne of the King of England. Yeah, and that was Will's favorite movie of all time. And
hey, listen, I'm going to roll with this, Rob. It's still my favorite movie of all time. I think it is a phenomenal movie. It was Oscar worthy, and I think it really was groundbreaking in both cinematography and script for the time. And
really came around like at the height of John Goodman. You know
This was Roseanne Barr, John Goodman, like they were dating, and it was just they were always being mocked on Saturday Night Live.
Yeah. Anyway, that was actually Tom Arnold. But okay, so
that was Tom Arnold.
Anyway,
see who knows?
So that's right. So anyway, not to beat that point up, but anyway, we actually loved last week's episode so much that we decided to have Scott back.
Yeah.
As the second guest that this show has ever had.
Yeah.
Will, who is Scott Fields?
Scott is a probate and real estate attorney in Tucker, Georgia. He graduated from Georgia State University College of Law. Georgia State University College of Law. That is our alma mater, and I felt like I said it wrong. In 2011. For about 5 years after that, he was a real estate, small business, and probate litigator. He formed his own firm this past February, and he focuses on estate planning and administration.
Don't call him a software engineer.
The last time I mentioned that he was a software engineer, and he pointed out, guys, I was only briefly a software process engineer, and that he did a lot of IT support. That just goes to show you that was a field of technological expertise that we don't have, because I still don't know the difference between any of those things.
Yeah, maybe he'll explain that at some point. But anyway, we're exceptionally glad to have Scott back. Scott, how are you doing today?
I'm doing well, thanks. Thanks for having me back.
All right. So getting right down to the biz, this episode, I don't think we got to everything we want to talk to last time. So this week, I wanted to actually have you take us through some scenarios.
Yeah, and one of the things that I wanted to start off right with the bat was something that we left off with last time, because I've had a lot of people inquire further with the process of what happens when somebody dies and you've got a surviving spouse and you have children. One of the questions that we got was, and this happens frequently in a lot of our cases. Let's say that a nursing home resident dies. We get a settlement or a verdict. We've got money for the estate. And you have a surviving spouse and you've got children, and one of the children has had nothing to do with the parents, has had nothing to do with the family, never visited mom or dad in the nursing home, lives in a different state, has never gotten involved, and the rest of the children are feeling, rightfully indignant that, hey, you shouldn't be sharing in any of the proceeds of this. What can you give us a general 40,000-foot view of what do you do in that situation?
Well, sure. If there's a will, it's very simple because whatever the will says is where everything goes, and it doesn't matter. There's no conditions that are, unless there's conditions put into the will, which is not common. But whatever the will says, that's what happens.
Okay.
If there is no will, then what takes over is what we call intestate law, and that's determined by law instead. So if you've got one spouse and two children, and the spouse and one of the children were very involved in the person's life and the other one was not at all, it doesn't matter. It doesn't matter because the law would say that second child who, probably hadn't seen mom or dad in 30 years is still going to receive 1/3 of the assets that are left over.
Okay.
Again, so those things simply do not get taken into account.
Interesting. Yeah, because I can't tell you how many times we have situations like that where somebody, the child will hire us, we'll go through the process, and we'll discover, during our case or litigation that, hey, we got a brother, out in Oregon, but he's never, and there's always but he's never been involved. And I guess the reality is, hey guys, it doesn't matter. I mean, it didn't matter that John Goodman was never involved with, the British Crown.
That's right.
King Ralph was still King Ralph.
Yeah. And that's sad. I'm not saying that's a good thing or a bad thing.
Sure.
I have my opinions, of course, but it is what it is. That's what the law says. And I've got several cases that I could tell you where that's exactly what happened. And people who, again, in other people's opinion, did not deserve to receive a dime, received everything or almost everything. So.
Okay.
So what happens when there is an heir that exists, but you're unable to get a hold of that heir? The guy the King Ralph guy in Chicago, we know that he's walking around, but maybe he lives off the grid, something like that. Like what's the process when that happens?
Sure. So in Georgia, the court would appoint someone called a guardian ad litem. If you identify someone in the petition, and you should, if you identify someone in the petition who is an heir, but you cannot contact them, you don't have their information, you don't know where they are, then you tell the court, it's part of the petition, and then the court will appoint an attorney who does not work for the court. So actually, I have been appointed quite a few times. It's called a guardian ad litem, and that person's job is simply to try to find what we call the unknown heir. And you'd be surprised at how helpful Facebook is. I've found several people doing that. If the family is a little bit older, you can use Ancestry.com. I've been able to do that. And really what both Facebook and Ancestry do is put you in touch with people who might know. So there may be, an aunt or a second cousin, twice removed, who you would never have thought to contact, and you may not have their immediate contact information. But you send them a little message through Facebook or through Ancestry.com, and they'll say, "Oh yeah, I know there was Jimmy and Johnny, and they live in Des Moines," and then that'll help you a lot of times get in touch with that person.
I guess I never thought about that.
Yeah.
Man, social media makes the world smaller.
Yeah.
Yeah,
and it's
really
a good way
helps.
to track people down.
Yeah. So okay, that makes sense. Let me throw this at you. This is another hypothetical.
Okay.
What do you suggest? What do you recommend for an individual, like the son or daughter of a nursing home resident that's passed, that's not on good relations with any of the other siblings? The siblings have different ideas of who treated mom better, who treated her worse, who's entitled to whatever. Is there a anything that you advise, whether it's mediation, counseling, or whatever, that would facilitate the letters of administration being drawn up in the quickest, most painless way possible. Like, Rob, I advise them to go and seek individual counsel. I'd advise them to go and sit in a room with padded, walls and padded bats, and they beat each other until they get it out of their system. Like, what do you recommend?
And just to unpack what you're asking him here, we're talking about a situation where we're having somebody petition the court to be the administrator, and there's bad blood.
Yeah,
right.
Bad blood. Taylor Swift.
Yeah.
Sure.
Katy Perry.
So the first thing I recommend is that people talk to each other, at least make the initial contact, because people will sometimes call me and they will basically have decided in advance that they're not going to be able to talk with the other person. The other person is not going to be reasonable. I would normally recommend that someone go ahead and make that phone call. Let them know what's going on. Let them know that you're planning to file a petition or that a petition needs to be filed, because you want to get ahead of the game. You want to get it in advance of creditors or in advance of somebody else who files it, because if nobody files the petition, then the estate doesn't move forward and those assets just sit there. And if you've got a house and the mortgage needs to be paid, then you need to pay that mortgage, or else the house is going to be lost to foreclosure and you've lost a significant asset of the estate. So first, I encourage people to go ahead and talk. If people have talked and things are just not going well, then what I recommend is go ahead and file a petition. Just file it. And because that usually will get everybody else to kind of wake up and take notice, because a lot of people have in their mind that if you do nothing, things just stay the way they are. And so if you file that petition to probate the will or the petition for letters of administration, then that will usually get people to wake up and to start, hopefully start talking about what needs to happen. But even if they don't, then filing the petition begins the process. And once the legal process begins, someone can delay it, but it's very, very difficult to halt it completely. So, but you can't end if you don't begin. So talk it out. If talking it out doesn't work beforehand, and I would not recommend spending a long time on that, maybe a month. That's just my personal preference. Go ahead and file it. And then hopefully that will either spur a conversation or the other person will simply ignore it and you can just move on.
That makes sense. Yeah, because it's almost in some instances like you're saying, it's like a race against the clock if there are creditors. You want to get out in front of that.
Yeah, again, everything in terms of what assets exist, what debts will be paid, how things will be dispersed, all of that is according to law. So a lot of the fights that I see are people think, well, if I'm the administrator, I get to decide what goes where. That's not true. If there's a will, it goes according to the will. If there's no will, it goes according to, the laws of intestate succession, which is basically the law says, this much goes to this person, this much goes to this person. So a lot of times once everybody realizes that, the fight just goes away. Now, if there's really bad blood, it doesn't, and eventually the court will hold a hearing and the judge will decide who gets to be the administrator, and then you just go from there.
There's a really famous, I think we joked about this before, there's a really famous Charles Dickens book called Bleak House that has to do with a fight over an estate that ends up just decimating the estate. Of course, I hit the microphone. Decimating the estate, and because of the contentiousness of the heirs, eventually there's no, spoiler alert for anybody who hasn't read Charles Dickens yet, that there's no money left in the estate. So, hey, I'm sorry that wasn't a John Goodman 1988 reference, but it's still a very famous reference.
Yeah, and that's the first Dickens book I ever read, actually. It's one of the only, is Bleak House.
Yeah.
And that's not necessarily what would happen in Georgia, because the costs of fighting that sort of battle would not immediately come out of the estate itself. You can get some of those costs recovered from the estate, or the administrator can, but I have not yet seen something like that where, both sides are taking out of the estate as they go, and then the estate goes away, and then everybody just, simply stops and walks off.
So here in Georgia, people have to pay to play. They've got to pay for their own attorneys if they're fighting these estate issues.
Yes, and there are some times when the administrator can recover those costs from the estate. Sometimes they can't. It depends on what the fight is over, and it depends on the circumstances of the dispute. But the administrator can recover. The non-administrator generally cannot. And again, that's all very general. There are circumstances where either or both can happen.
And just as a practical matter, to explain to our listeners and viewers, when we're talking about an estate, let's say that there is an administrator or an executor set up, what type of bank account, like where is that money held for that estate? What is the estate? Describe what an estate is.
Sure. So the estate is, it's a little difficult to understand. It's a bit like a corporation in that it is similar to an entity. So it's a thing that has certain rights and certain responsibilities, and that's not 100% accurate, but it's a good approximation.
Sure.
So, but an estate generally is the collection of the person who passed away, of their assets and their debts.
Mm-hmm.
That's really it. That's the estate. The estate is the assets that they have and the debts that they have when they pass.
And where are those assets held?
Well, before the estate is probated, the assets are, they're where you were. If it's a house you owned, it's the house that's sitting there. If it's money that you had in the bank, it's the money in that person's bank account and checking account. Once the estate begins to get probated, the job of the executor or the administrator is to collect those assets, to move them out of the decedent's bank account, and put them into an estate bank account. Part of the probate process is the administrator or the executor setting up an estate account. And, a lot of banks will, you walk in, you say you need to set up an estate account, they'll know exactly what that is. But the assets, when someone passes away, they remain where they were the day before they passed away.
Mm-hmm. Interesting.
So, Scott, look, let's back up a little bit more. Can you what are letters of administration? Like, what does the paper look like? Like, is it? I mean, what's contained in it? The actual content of it.
Sure. So letters, there's two types of letters. We'll get into that in a second. Letters are basically orders from the court. So it'll have in it things that other court orders will have. Basically, the judge signs something, or the clerk will sign on behalf of the judge that says this person is the administrator or this person is the executor, and they have these types of powers, these authorities. For letters of administration, if there's no will, then you would receive letters of administration. There are additional points on the letters that say whether or not the person has to have a bond, whether or not that person has to file reports or give an accounting on a regular basis to the court. There are circumstances where the person does not have to do those things, and there are circumstances where that person does. But I mean, it's basically an order. It's an order telling the rest of the world this is the person who has the court's authority, the legal authority, to carry, to deal with the estate, to take those assets out of where they are, put them into an estate account, disperse them, use them to pay debts, and the authority to settle those debts in a lot of cases.
Does something have to run in the newspaper? Is that like old school?
Yes, you do. You have two things that generally run in the newspaper. When you first file a petition, you have to notify all the heirs, and just in case you missed anybody, you run a notice. The court will actually usually contact the paper, the legal paper, and publish a notice saying, "Hey, so-and-so has filed this petition. You have until this date to get an objection." Whether anybody reads those or not, I don't know, but it is what it is. That's what the law says. So that's the first time something runs in the paper. The second time something runs in the paper is after the person is appointed as the executor or the administrator, you publish what's called a notice to debtors and creditors. And this is what people pay attention to, usually the lenders. They just comb through these, and when they see somebody that owes them money, then they send in a claim. And the notice to debtors and creditors is just that. It says, hey, this person has passed away. So-and-so has been named as the executor or as the administrator. And if you want to file a claim, if you want to say, hey, this person owed me money, then you need to send in a written notice. And, it gives the executor, the administrator's address. Here's how you get in touch with them. And again, this is usually banks or it's credit card collectors. There are companies out there where, they buy these debts and this is what they do. And they will watch for these notices in the newspaper. They'll send in written claims, and then, you hold on to those until the time comes to pay those debts. Those are generally the two.
Right. Do you have an understanding as to whether a potential lawsuit that would lead to recovery is an asset of the estate?
Yes. If the person who passed away has a lawsuit or has a claim, then yes, that is technically an asset. It would be just like if the person had loaned somebody else money. So let's say, for example, I loaned my brother some money, and I passed away, and I've got that note written down somewhere. Then my estate would collect on that debt, would collect according to that note.
So, I'm sorry. Go ahead.
I actually had a question because we kind of glossed over something, and I know that I've encountered this before, and it's been an issue for people. You mentioned earlier that there may be a bond that's necessary. What do you mean by bond?
Sure. When someone passes away and they've got assets, the executor or the administrator is basically what we call a fiduciary. It is a person who has very specific obligations towards the other people. So it would be towards the other heirs, for example. So if someone is asking to be appointed administrator, then they are going to be handling money that does not belong to them. And so that person has an obligation. And to protect the people, that the money belongs to, the court will normally require that person to post a bond. So if the assets of the estate are $100,000, then the court will say you need to go get a bond for $100,000, and you'll call a bonding company, and you'll get you tell them I need a probate bond, and they generally, the bonding companies know what those are. So, and again, that's security in case the administrator, takes the money and runs off to Belize or whatever. Then, the estate can get their money, and then somebody gets to go after the guy in Belize.
What happens? Because some of our clients are in different socioeconomic levels. What happens if they don't have any money, or nobody in the family really has any money or any assets?
Yeah, does that make the process quicker?
Or does it make it slower?
No, it makes it more difficult. I'm actually dealing with a case where that has happened. So sometimes you do get, or you can get the cost of the bond. I don't know if you call it a premium. You can get that paid out of the estate. It's one of the costs of administration of the estate. So you can get that back. So if it's an issue of, I've got enough in my savings account to cover the cost of the bond, but I was going to use that to go to Disney World in a couple of years. Well, pay it, you'll get it back, is generally what I recommend for people. If you just simply have no money whatsoever, you can go to the court and you can ask, hey, can I get the bond waived? Or in what we're doing in the situation I have now is you ask that instead of the person that's be appointed as the administrator of the estate, then you ask for the county administrator. And the county, each county has an attorney or some attorneys who act as the county administrator, and their job is to be a neutral administrator. And they have to have, by law, they have to kind of keep on tap a bond. And that's, and so that's who you would get to be the administrator instead. And again, because all of the paying of the debts and all of the disbursement of the assets is done by law, again, it doesn't matter.
It doesn't matter. I feel like a lot of our clients have perhaps not really understood that. The one thing that I will say, though, is it does, when we have an administrator, they do get involved with how we settle the estate, whether or not we settle the estate. But I think a lot of people fail to realize that the administrator isn't just saying, "Hey, you get some money, and you get money, and you get a car." No, it's like Scott is saying, it's by law.
And Scott, one more question before we wrap this up. With regard to that, with the estate, like how long does it take to? And does it ever close? Like, so in this example where a loved one has come into our office with a potential claim for negligence against the nursing home for causing the death, that claim is held as an asset by the estate. So when does the estate actually terminate its business? When does it conclude its business?
Sure. Well, it concludes its business when everything is paid out. I mean, basically, and that can take months. It can take years. I'm trying to think offhand of the longest estate I've ever seen open, and you're talking, and I just remember it being over a decade. And so what happens is someone's named the administrator. They publish this notice to debtors and creditors. They publish it for 4 weeks. After that, the creditors have 90 days to send in claims, and then you start paying off the claims. Once you pay off the claims, against the estate, then you can disperse the assets. In a situation like you guys deal with, where you've got a lawsuit, and that lawsuit may take a while, then you just leave the estate open. That's not a problem. Mm-hmm. And once all the assets, because a claim is an asset of the estate, the administrator, the executor has an obligation to go after it and to do the best that they can. But basically, once all those claims have been made, or the statutes of limitation have run, so all the money that could be coming in has come in, you disperse the assets and you close the estate.
Excellent. That makes sense to me. Scott, just so my understanding is that it is extremely likely that you first started reading Charles Dickens because you went to your public library, or maybe it was assigned reading in your middle school or high school. In fact, for Will, he discovered Dickens through a type of the gods must be crazy scenario where a guy was piloting a small cargo plane and dropped by accident the book from his plane, and it landed in
the mountains
in Will's mountain village. And at first he was using it to help scratch his back. He was trying to eat it and realized he couldn't eat it. He was using it to prop things up at his house. Then finally he realized it was in fact a book, and in fact a classic book.
And that is how we discovered language in Saucy Nakuchi.
In his town. That's right.
Yeah.
At any rate, Scott, we appreciate your experience, your knowledge in this episode with regards to loved ones who've had people in their family pass.
Absolutely, man. You're amazing as always.
We hope to have you back again.
You
were the first and second guest ever on this show, so we hope that you wear that badge with honor.
And if people,
I do. Thank you.
Absolutely, man. And if people want to get a hold of Mr. Fields, his number is 404-532-9953. That is the best way to get a hold of him because he is older. And like he said last time, he doesn't respond to tweets or Snapchat or Instagram. But it's 404-532-9953. Or you can go to sbfieldslaw.com.
And just again, as a CYA, nothing that you've heard on this podcast or any one of these podcasts should be considered as legal advice.
Absolutely
for
not.
your specific situation. This is given in a general, educational, and informational purpose only, and that is on behalf of both Will and myself, as well as Scott Fields. And on behalf of Scott Fields, myself, and Will, we hope you enjoyed this podcast, and we will see you next time.
See you next time.
Thanks for tuning in to the Nursing Home Abuse Podcast. Please be sure to subscribe to this podcast on iTunes or Stitcher, and feel free to leave us some feedback. And for more information about the topics discussed in this episode, check out the show website, nursinghomeabusepodcast.com. That's nursinghomeabusepodcast.com. See you next time.